Good morning, everyone. Thomas Montgomery. It's a beautiful Monday morning, June 13th, 2022. It's 8 o'clock Central. We get together with our distribution partners most weekday mornings at this time to talk about strategies, tips, techniques, success stories, and to support each of you. We're going to talk about the topic of litigation today, and this is relevant if you're a white label partner, because it's a strategy that you may want to use to collect money that's owed to you. We'll talk more about that. If you're one of our debt buyers, in other words, you're buying debt, buying accounts receivable, what we call the collateral support program, litigation can be an important tool for you as well. If you're just simply a referral partner, you're welcome to sit in on the training, but this wouldn't be quite as relevant for you because you're not really involved in those other aspects. When we talk about litigation, I think litigation is commonly misunderstood. And so it sounds negative, it sounds bad, it sounds uncomfortable, like who wants to go to court? But it is within our constitutional rights as a United States citizen to be able, it's called the debtor's rights, DEBTOR', as the creditor's rights, I'm sorry, the creditor, you, has the legal right to collect from the debtor money owed. And so litigation is one strategy to go about doing that. So let's talk about in the two different scenarios, and then I want to leave plenty of time for questions and answers. So if you're a debt buyer, so in other words, you're using the collateral support program for probably one of two reasons, one of which is just to make money off of it, which is fine. Buying and selling debt instruments is a very popular strategy. Usually it's done by high net worth individuals, and they're usually buying portfolios of defaulted mortgages, defaulted credit card debts, defaulted auto loans. However, it can also be facilitated by creating portfolios of defaulted professional service agreements. And that's what you and I work with these portfolios. So it's designed to generate income for the debt buyer. And then in some cases, people will buy the portfolio to add assets to their balance sheet because they have a collateral shortfall. That's less our discussion today. But if you are a purchaser of a portfolio, that means that there is a group of people that now owe you money because you bought the defaulted debt instruments, not mortgages, not auto loans, not credit card debt, but the same concept. So now you have these defaulted agreements, written agreements that people have breached. So they're called non-performing assets. The people aren't paying on them because if they were paying on them, they wouldn't have probably been sold. So with that, if you're a debt buyer, how do you go about getting the money out of that? Because while you do have the accounts receivable, which is a real credible asset, and in some cases that can be used to access financing on its own through AR financing, invoice factoring, and so forth. But we'll again set that aside for a different discussion. You want to move the AR into cash, just like if you and I had a lawn care business, right? We had a bunch of people sign up for lawn care contracts. We're like, oh, this is great. We sold 100 new lawn care contracts for $100 a piece, $10,000. Well, how do we pay our bills with that? Not so easy. We need cash. So any business should seek to transition AR into cash. No difference as a debt buyer. There are three main ways to liquidate accounts receivables as a debt buyer. The first of which is collections, which is not our discussion today, but we at least have to hit upon it. So collections just simply means, hey, I'm going to try to collect the money that people owe me, right? And you could do that internally. Most of us probably don't want to do that because you know what's going to happen. You're going to call them and they're going to say, well, I don't owe that, or that's not real, or what have you. And now you're playing the role of a third-party debt buyer or a third-party debt collector, and there's a bunch of regulation that you have to follow or you get in trouble. So most people don't want to be a debt collector, but there certainly are third-party debt collector firms that we could refer you to. So that's one strategy of how to liquidate the AR if you're a debt buyer. However, I'm a bigger proponent, not opponent, but proponent of litigation, which we're going to talk more about. Litigation, as the creditor, you have creditors' rights, and you're going to be able to, in almost every instance, win in litigation. So liquidation through litigation. And we'll talk a little bit more about that process here in just a moment. The third most popular way to liquidate the AR when you buy a portfolio is to resell it. And of course, you'd want to resell it ideally at a profit. And so you could certainly do that. So let me give you an example, and I think it's a reasonable one, and then we'll move on. So let's say that you saw 10 acres for sale. And often if you buy 10 acres, you can get an affordable price because a lot of people don't need that much acreage. So you buy the 10 acres and you say, you know what, I'm going to sell then each acre separately. And that's a more manageable purchase for a typical home buyer, and they could go build or put a manufactured home on their acre. Would you be able to sell each acre at a premium over what you bought the 10 acres for? Sure. And so that would be a similar concept. You could be a debt buyer, buy the portfolio, and then start selling off chunks of it at a premium, or the whole amount at a premium. All right, but let's drill into litigation, which is really our conversation for today. So when it comes to litigation, you can, and this is we're going to dispel some myths about litigation. Now, I'm not an attorney. I can't give legal advice. I am a paralegal from Rice University, for whatever that matters. We have law firms on retainer, so I've gone down this road enough that I can talk, I think, in an educated fashion about these topics, but I'm not giving legal advice. So regarding litigation, what's really amazing that a lot of people don't realize is you can often collect more than what was owed, what's called on the principal amount, because you're going to be able to collect late fees, court costs, etc. So let's go back, because right now we're talking about the debt buyer. So let's say that you bought a portfolio of $100,000. Well, how much of that do you want? You'd be saying, I want all my 100,000, right? That's what these people actually owe me. Well, if you use third-party collections, while they may not charge anything up front, they're going to obviously want a piece of what they collect on the back end. And they often are more likely to negotiate payment plans and within the constraints that you approve. So if you bought a $100,000 portfolio and you used exclusively third-party collections, would you end up with $100,000 in your bank account from that purchase? Probably not. You're gonna get less than that because those third-party collectors want to be paid. In contrast with litigation, not only can you collect the full 100,000, but you can actually collect a premium. And that's the point that we're making here. Collect literally more than what is owed when you consider late fees. The agreements that are part of the portfolio almost always have $50 a day late fees. So think about that for a moment. In 1 month, just say it has an average of 30 days, that's $1,500, $1,500 of late fees. Well, do you think that if you bought a portfolio and decided you wanted to litigate, that it would be litigated in 30 days? No. It's probably going to be 60 to 90 days. So now you've got an extra $1,500, $3,000, $4,500 of money coming to you that's owed to you in addition to the principal amount of the breach. So that's a poorly understood strategy of litigation versus collections. Collections, you're going to often get less than $1 for dollar because of the collector's fees. In litigation, you're often going to get more than $1 for each dollar owed. Wow. And in today's environment where the stock market's going down, cryptocurrency's volatile, inflation's going up, when you can bring in more than your principal amount, it's excellent. Now, I understand the constraint, and so this is where we're getting to some new information. A number of you are debt buyers, and you just simply aren't really comfortable with doing the litigation yourself. So we respect that, because we do it on a daily basis. We probably issue just over the weekend, I don't know, close to 100 new citations. This week alone, we'll probably issue $6 to $7 million of new citations. So this is what we do on a regular basis. And so we've figured out a way that legally and effectively we can handle this for you if you want. So if you're a debt buyer and you say, great, litigation sounds good, but I don't want to have to do it myself, I don't want to have to do all the steps that are involved, we can do it for you. So let's talk about some of the most significant steps. And this would be true if you wanted us to litigate it for you, or if you wanted to do it. Regardless, let's go through some of the high-level steps. So the suit has to be filed. You have to file the lawsuit with the court. And so that is important in how it's created. And there's going to be a filing fee that the court is going to collect. There's really 3 levels of courts in the United States that are relevant. We're ignoring the appeals courts and ignoring Supreme Court, both at the state and federal level. But we have federal courts, state courts, and then what's called JP, or small claims courts. We find that it's the easiest to navigate through the small claims court system. The filing fees are less, the documentation that is needed is also less. So regardless if it's you or our litigation team, the suit will need to be filed. Once the suit is filed with the courthouse, then the defendant, because in this case you'd be the plaintiff, the defendant has to be served. They have to receive notice. And there's a few different ways that they could receive notice. It possibly, depending upon the court and the judge, could be allowed to be sent via a certified mail, return receipt requested. Some courts will insist on personal service. Personal service is very popular. So let's take Joseph, who's on the line, one of our white label partners. And so let's say that Joseph has someone that owes him money. And so once Joseph files suit, or we can do it for him, what's going to happen is that someone's going to show up, if it's personal service, the example we're talking about now, and knock on the door. And here's the police standing outside. So now your family is seen, police show up, and police are going to serve that person. You've been sued. Or we could have the person served at work. Very effective, because it's very embarrassing to be served at work in front of your boss, your coworkers. So someone's going to have to arrange for the serving of the suit. If you use our litigation team, then we'll do that. Otherwise, that's a step that you'll need to do. It's not all that burdensome. We have a company that will do it, that will serve nationally, so we don't have to go find the local sheriff in the given county that the person resides. But that's the second significant step in this process. Where a lot of people miss is, a lot of people are not very sophisticated when it comes to litigation. So what they think is, oh, file the suit. Of course, we're going to serve the person, give them proper service, but then go to court. Well, the money is made on step C with motions. Now, those of you that are attorneys, those of you that are also paralegals, know that there are different types of motions. Motions for discovery, for example. So that's where the plaintiff, in this case you, or if we're doing it for you, us, is getting a court order that requires the defendant to provide a shitload of information. A lot of information that's relevant and necessary. So it's not punitive, it's not being mean or unethical, but it's a lot of information that they have to pull together. So far, the largest request that we have seen was over 100 questions that went to the defendant. And each question isn't just this, it's provide this, provide that, provide every email from the date of contract to current, provide phone records, text records, bank records. And so it can just be freaking exhausting, but it's called discovery. And that's something that you as a creditor have rights to be able to get the information you need to prepare for that lawsuit. That alone can be just effing crushing to the defendant. They're like ready to just tap out. Just tell me where to pay. There's also other motions and strategies that we won't go into today, but this is where the money is made in the motions. And then ultimately, then the court has to be held. So if you use our litigation team to resolve this, then we'll go to court and we'll take care of that. Now, we don't normally do court via Zoom, and we normally don't do court via phone call. It's normally in person. And that's an important tool, because that means that the defendant has to get on a plane or on a bus or a train or drive in a car and show up in Wood County, Texas, which isn't the boondocks, but it's not real convenient. So our approach is to do in-person litigation. That the court has the jurisdiction to decide, are they going to require that? Our courts typically will enforce that, even though we've gone through the pandemic and such. And so that's another strategy for higher success. Once you start to deal with more volume, that doesn't always happen. I know on August 10th coming up here, which is about 2 months away, we have so many cases scheduled on the docket, all with one judge that we know well. And we just every 15 minutes, bam, 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 bam. And the judge decided to do those via Zoom, because again, on breach of contract, it's almost an automatic victory. And so it doesn't take long. And so we might end up having 20 cases back to back to back to back to back to back to back. So in that case, those frankly are being held via Zoom, but normally in court. So what's the point? If you're a debt buyer, you want to be focused on liquidating your accounts receivables, because that's how you move it from AR to cash. There are a number of different ways to do that. Litigation is one that you may want to give more consideration. A lot of you have leaned towards collections, but I think litigation may generate better results and a higher return for you. And if you want us to do that for you, we can do it for you if you're a debt buyer. Okay, so there's from the debt buyer perspective. Now, from a white label partner, this is going to look almost the same, so the conversation will be brief here. If you're a white label partner, what are you doing? You are signing clients up under your agreement, And so we've had training on that. You know where to find that on iimfl.org, white label page under the YouTube videos. It's the submission form. Right underneath that's the agreement template. You make whatever changes you want, get the client signed. They're contracted with you, not with us, they're contracted with you. And then you submit on the submission form. Well, what happens if the person breaches the contract? You might say, whoa, wait a minute, Tom, what does that exactly mean? So I'm a white label partner. How could someone breach? Well, they might breach by getting capital and then not paying you. So that's possible. They could fail to have a failure to perform, so they don't stay engaged and they still owe you, right? If you look at the agreement, depending upon how you've changed it, if you haven't changed it, they still owe you probably over $10,000 if they signed up, even if they just walk off into the sunset. Well, if they don't pay you, then you again have creditors' rights. And so you'll want to collect that money. So just as before, as we talked about with debt buyers, if you're a white label partner, you can often collect more than what's owed on the principal amount. So while you don't, as a white label partner, you don't want people to default on their agreements with you, but it's not all bad in the sense that you actually should generate more income if they defaulted than possibly if they participated. So it's not the goal. We don't want that to happen, but it just gets very expensive for the defendant, for the debtor, if they don't comply. So again, number 3 is exactly as before. So we have a number of white label partners that have some clients that have breached the agreement between the client and the white label partner. And so this is all exactly as we talked about before. Now we have to do the paperwork to make this legal and appropriate. We are not a law firm. We are not attorneys. We're paralegals. And so there's certain things we can do and certain things that we can't, but we can certainly take care of the litigation for our white label partners who need assistance in collecting from clients that have breached and or from debt buyers. All right, so we've got a few questions, and if you do have other questions, go ahead and post it and we'll address it. So I'll leave the name off record here, but one of you is a white label partner, and it sounds like you recently received a court citation for a lack of participation. So that's true. If you're a white label partner, there's certain promises that you've made, promises we've made. And so if you haven't upheld that, then of course, what can in fact happen is we can end up needing to resolve it in court. So I apologize if that's happened. We always word it where we want to resolve it, not go to court. So if you just read the invoice and the court citation you received, we can resolve it without going to court. And that's true for you all as well. So, you know, if you have debt buyers, if you're a debt buyer and you have people that owe you money, the goal isn't necessarily to go to court, it's to get them to pay what they promised to pay. If you're a white label partner and you have a client that breaches the agreement, the goal is not to take them to court. The goal is to get them to pay what they agreed to pay, of course. All right, so questions, comments, concerns that anyone has on litigation as a remedy for those of you that are debt buyers and or white label partners. Questions, comments, concerns. All right, well, I think that's the training for today. We will see you back tomorrow morning. Thanks everyone and have a great day. Bye-bye.